Good afternoon, everybody, and thank you for attending today's webinar. My name is Sara Sawicki, and I'm a partner here in the employment team at gunnercooke. And the topic for today's session is shared parental leave. Now, if you listen to Nick Clegg and Vince Cable, they'll have it that these new regulations are going to take us into the brave new world of gender equality at home and at work, where men share and play their part in caring for their children, and that they're going to smash the old stereotypes of where childcare is a woman's domain. Others, however, say that these regulations will be a damp squib, that they're going to make very little difference in practice, and that they're going to create a lot of headaches for HR departments who are busily preparing their policies and procedures and forms in relation to these new regulations. And in fact, very few fathers are likely to take up shared parental leave. It'd be interesting to see what people on this webinar think once I've gone through the essential provisions of shared parental leave regulations. So, as a starting point, the shared parental leave regulations are in force already. They came into force in December 2014. Have to say, my impression speaking to employers is that very few have actually done anything about them. Very few have finalised policies, very few have finalised forms, and very few have trained line managers in what shared parental leave may mean. Now, I get the impression that this is a topic where it's a little bit too difficult to deal with and it's put on that pile. But the reality is that shared parental leave will apply to parents whose children are due to be born on or after the 5th of April, or in the case of adopters whose children are due to be placed with them on or after the 5th of April. So, for those babies which are born prematurely, and it may be the case that you have employees whose babies were due to be born on or after the 5th but who've been born already, those parents will qualify for shared parental leave rights. And the purpose of today's talk is really to give you an overview of the regulations and an understanding of what it is you need to do if you haven't done it already. Now, I would say this, that these regulations are ridiculously complicated, they're incredibly detailed, they're set out in 11 different sets of regulations, and I am not going to go into the technical detail, if at all possible, because I think if I start going down into the technical areas, it may just simply serve to confuse. If you are very au fait with the regulations and you do have some technical questions, I'm very happy to take them later. And if you do want to pose questions, I'll answer them at the end of this session rather than as we go along. So what I would say for you techies out there, if there are any, if you're very interested in the technical aspects of the regulations, do read the BIS Technical Guidance for Employers. It's a 65-page document, it's incredibly detailed, and it answers every single question that you might have at 1 o'clock in the morning, which is what is coming to my mind at 1 o'clock. I've been dealing with this for quite some time now, and every time I think I've got it, something else arises. So I have to emphasise that they are technical, detailed, and that's not the aim of today's session. I'm not going to go into that. So, just a reminder of the current position, just to put the new regulations into context. So a mother is entitled up to 52 weeks of maternity leave. 26 weeks will be ordinary maternity leave and 26 weeks will be additional maternity leave. In terms of pay, the first 6 weeks will be paid at 90% of her salary, and the following 33 weeks will be paid at the flat rate, which is currently £138.18. So she's entitled to up to 39 weeks' pay in total. Now, for the father, he will be entitled to 2 weeks ordinary paternity leave, and that will be paid at the flat rate. And here's something that you may not even remember about. Fathers are actually currently entitled to up to 26 weeks additional statutory paternity leave. This can't be taken before the 20th week after birth, and it can only be taken if the mother has returned to work early. Now, it's interesting that the take-up of additional statutory paternity leave has been minimal. And I would say the reason for that is probably because it's paid at a flat rate of £138.18. Now, I'm not going to go into the details relating to adoption leave. All I will say is that the provisions relating to shared parental leave for parents who are expecting a child also apply to adopters who are expecting to be placed with a child on or after the 5th of April. So, as I mentioned, these regulations are already in force. ACAS have published shared parental leave, a good practice guide, and I would recommend that you read the guide. It's fairly straightforward, it's a nice overview, and it has some good tips. Now, as I mentioned earlier, the system applies when the baby is due on or after the 5th of April. So if the due date is on or after the 5th of April, but the baby is born earlier, parents will be able to access shared parental leave. Conversely, if the baby is due to be born before the 5th of April, but is in fact late, so the due date was before the 5th of April, the baby is born after the 5th of April, the parents will not be entitled to shared parental leave. They will be entitled to the current regime of statutory maternity leave, and fathers may access the additional statutory paternity leave provisions. So what's changing and what's not? Well, the maternity leave and pay regime remains without any change. So 52 weeks leave and up to 39 weeks pay. The paternity leave and pay regime will change. So fathers will be entitled to 2 weeks of ordinary paternity leave and pay at the flat rate. But that additional leave period that we just talked about, which has not been taken up very widely anyway, that is going to be abolished and will be replaced in its entirety by the shared parental leave provisions. Some interesting changes to adoption leave. The right to leave will become a day one right. So currently, the primary adopter has to have been in employment for 26 weeks at the end of the 15th week before the expected week of confinement. So there is a continuity of employment test that goes. And also, currently, adoption leave is paid at a flat rate throughout the 39 weeks. As of the 5th of April, that's going to be paid at the same rate as statutory maternity pay, so 90% pay for the first 6 weeks and then the flat rate. So, an outline of shared parental leave. Now, a partner does not have an autonomous right to shared parental leave. The right only arises if the mother chooses to curtail her maternity leave and her maternity pay and share the balance of her maternity leave and pay with her partner. So shared parental leave is optional, and the default position is that the mother may have her entire right to 52 weeks of maternity leave and 39 weeks of maternity pay, if that is what she decides to do. However, if she does decide to share her maternity leave with her partner, both parents will be entitled to up to a maximum of 50 weeks of leave and 37 weeks of pay. And the reason for that is the first 2 weeks after birth are compulsory maternity leave periods. So 2 weeks will automatically be taken up as statutory maternity leave and statutory maternity pay. Now, the scheme is very flexible. Parents can apply to take time off together or separately, in one continuous block or in discontinuous blocks. Employers can reject some but not all patterns of leave requested. And the starting point has to be that the mother curtails her entitlement to maternity leave and maternity pay. Now, she does this by submitting a notice of curtailment or simply returning to work. Now, when she curtails her maternity leave, it doesn't mean that her maternity leave comes to an end immediately. she can give a date in the future, let's say 10, 20 weeks time, where she says her maternity leave will come to an end. And that means she frees up with immediate effect shared parental leave for her partner. So you can have a scenario where the mother's still on maternity leave and the partner is taking shared parental leave. As I said, it can be taken in discontinuous blocks. The shortest period that can be taken is a week. It has to be taken in the child's first year, and each parent has 20 split days. So who can share? Well, you've got the obvious people who will share are the mother and the father. However, it doesn't have to be the father. It can be the partner or a civil partner or a same-sex partner, provided that that person shares the main responsibility for the care of the child. That is one of the criteria that has to be satisfied. Right, here's where it gets a little bit technical, I'm afraid. How do they qualify? So if your employee wishes to take shared parental leave, they have to have been in employment for 26 weeks by the end of the 15th week before the expected week of confinement. So it's the same test as for statutory maternity pay. But in addition to that, so what your employee has to satisfy that continuity of employment test, but in addition, your employee's partner has to be economically active, and they have to satisfy the employment and earnings test. Now what this means, and you know, this is essentially what it is, it's quite technical, but the partner has to have worked for 26 weeks of the 66 weeks before the birth and have had average earnings of at least £30 over a 13-week period. So that's it in a nutshell. Now, so it's quite a low threshold. And the same for adoption. The adopter, if your employee wishes to take shared parental leave, they have to have worked for you for 26 weeks at the end of the 15th week before they're notified of a match. And in terms of the economic test, economically active test, 66 weeks before birth is 66 weeks before placement. Right, okay, so there will be certain occasions where only one person in a couple is entitled to take shared parental leave and shared parental pay. So to give you an example, you have an employee, the mother, she's entitled to statutory maternity leave and statutory maternity pay. However, her partner is self-employed, so he satisfies the economically active test, but he has no employer from whom he can claim shared parental leave. So the mother is entitled to statutory maternity leave and pay, and her partner, although economically active, is not entitled to shared parental leave. So why might the mother in those circumstances decide to curtail her maternity leave and pay and opt into the shared parental leave regime? Well, the reason she might do that is because the shared parental leave regime is so much more flexible than the current statutory maternity leave regime. So if you think about it, a mother has to be on maternity leave for one continuous block, up to 52 weeks, but if she decides to come back to work during that period, that's it. She's lost her right to maternity leave and she can't resurrect it. She can't decide, oh, I'll go back to work for a month and then I'll go back on leave. The shared parental regime is much, much more flexible. To give you another example where the father is your employee, he satisfies the continuity test. Now the mother might not be employed. So for example, the mother might just have been made redundant before going on maternity leave, or she might have left her job, or she might be self-employed, in which case she'd be entitled to maternity allowance. So she might be entitled to statutory maternity pay because she's met all the thresholds for that, but she no longer has an employer. So she is not able to take shared parental leave. She doesn't have an employer to take shared parental leave from. But in this scenario, what she can do is she can curtail her entitlement to statutory maternity pay or her entitlement to maternity allowance, And in curtailing her right to those payments, she frees up shared parental leave for her partner who's employed. Right, so there are 3 key stages to taking shared parental leave. And the first stage is the mother must curtail her maternity leave period or her pay. The second stage is opting into shared parental leave and or pay. And the third stage is booking shared parental leave. So in total, there are 5 notices to submit. And this is where there has been quite a lot of criticism levelled at the regulations because it is very complicated. And it's quite hard to explain to employees what they must do and whether they, for example, are eligible or not. And I've been working on some policies, and I have to say, I don't think policies of themselves are particularly helpful. You can repeat, what the regulations require, the test for eligibility, etc. I think that the key and the most helpful aspect of any policy is to have forms for each stage. Stage 1, curtailing maternity leave, have a letter that the mother can submit to curtail her maternity leave. Stage 2, the opting in stage, and the intention to take shared parental leave, have forms, one for the mother, one for the partner. And the booking stage, that's relatively simple. But the forms, I think, will be very helpful, more helpful than the policy itself. So stage 1, in terms of curtailing maternity leave, the mother can curtail her maternity leave to create the shared parental leave by either returning to work, for example, after ordinary maternity leave, or giving written notice that she will end her maternity leave at a specified date of her choice. She has to give a minimum of 8 weeks, but she can decide to curtail her leave in 20 weeks' time, 8 weeks' time, 32 weeks' time. That's her decision, and in so doing, she frees up the balance to be taken as shared parental leave. Now, to be binding, she either has to submit notice of her entitlement to take shared parental leave, which is a stage 2 obligation, or she declares that her partner is eligible for shared parental leave and that she consents to her partner taking shared parental leave. Now, the curtailment notice is binding, and it can only be revoked in very limited circumstances, 3 circumstances, including death of partner. So it's quite important that a mum understands that when she is submitting a curtailment notice, that will bring her maternity leave period to an end at some date of her choice. But she can't undo that revocation. So stage 2 is where the employee gives notice of entitlement to shared parental leave or shared parental pay, and also gives details of their intention to take leave. Now, this stage is really prescriptive. There's a lot of specific information that has to be given, and I'm not going to take you through all of the detail. The key elements are on the slide. So the employee has to give notice of their entitlement. Well, that's something that you're going to know because they're your employee. They're going to declare that they meet the eligibility criteria. Again, if they're your employee, you will know that. But they also will include a declaration from the other parent that they meet the employment and earnings test. At this stage, the employee is also required to give you an indication of how much shared parental leave they're intending to take, how they're intending to divide it up, the types of patterns of leave they're hoping for, and also the patterns of pay. But this is not binding at this stage. Now, after you've received notice of entitlement and intention, you can request within 14 days a copy of the birth certificate if the baby's been born, and the name and address of the partner's employer. But if you recall, the partner may not be employed. All the partner has to do is satisfy the employment and earnings test. But if you do request that detail, the employee has 14 days to provide this information. So stage 3 is the booking of leave itself, and an employee must give at least 8 weeks notice of when they intend to start a period of shared parental leave. Now, each parent has up to 3 booking notices, and they can't, unless you agree to it, issue more booking notices. So the way it operates is that an employee can use one notice to book a period of continuous leave. If they book a period of continuous leave, then as the employer, you're obliged to accept it. You can't change it, you have to go with it, and they start their period of continuous leave on the first date in their notice. The employee can also use a booking notice to book discontinuous periods of leave. So for example, they could ask for 3 separate periods of leave in a booking notice. Now in this scenario, where they're seeking discontinuous leave, an employer does not have to agree. Okay? And then there is a process that applies to try and agree, and in the absence of agreement there is a default position. And I've set that out on this slide. So if we go across the top, if the employee gives a period of leave notice or a booking notice, if it's a single continuous period, then you'll see the arrow, the employee is entitled to take leave as of right, and the shared parental leave starts on the date stated in the notice. Now, if you look at the arrow down, if the employee is seeking a period of discontinuous leave, then there is a 2-week discussion period between the employer and the employee, and during this period the employer might agree to a pattern of leave, they might agree to alternative dates for leave, in which case there is agreement and this shared parental leave will start on the agreed dates with the agreed pattern. But if the employer refuses that leave pattern sought, the employee has 15 days from the original notice to withdraw their request, and if they do so within the 15-day period, it doesn't count as one of the 3 booking notices. Or if the employee doesn't withdraw the request, the employee's leave becomes a continuous period. So what they might have booked, let's say, up to 30 days, up to 30 weeks in a discontinuous pattern, well, the default position is that that 30 weeks becomes a continuous period and it starts on the original date issued in the booking notice. So that seems really complicated. Hopefully this chart will help summarise it. There is obviously more flesh on the detail there. So, in summary, if the employee makes a request for multiple periods of discontinuous leave, the employer can decline it. But if the employee applies for 3 separate blocks of leave using 3 booking notices, then you can't decline that. So, bizarrely, if the employee booked that 3 separate blocks of leave in 1 booking notice, you can say no. But if the employee then uses up their entitlement to the 3 booking notices and books 3 separate periods of leave, then you have to accept it. You can't not agree to that. So I know that some employers are saying this is going to be a nightmare, discontinuous leave, how are we going to possibly provide cover? What I would say is perhaps have an open mind, and when they give their first period, their first notice, booking notification, if they do set out periods of discontinuous leave, it gives you an opportunity to chat through what might be possible, what might not be, but it gives you sufficient notice. Because if the converse, the alternative is that you face 3 separate booking notices, which only gives you a period of 8 weeks in which to find cover. Now, the other thing I would say here is be consistent in how you accept or decline patterns of leave, because if you think about it, a lot of employers will be used to women taking single continuous blocks of maternity leave. So they might be inclined to turn down a request from a female for discontinuous patterns of leave, where they might be more inclined to agree to a request from a father for discontinuous patterns of leave because, you know, he needs to come back and work on his career, etc. So you need to be careful there, because obviously if you have different approaches, then you are potentially going to be discriminating against women or men for that matter. So it might be a sensible approach to make sure that these requests are dealt with by HR in conjunction with the line manager. Split days. So essentially these are keeping in touch days. So you'll all be familiar with the keeping in touch days that are available to women who are on maternity leave. So women have up to 10 kit days available to them during either maternity or adoption. And the purpose of a kit day is to enable them to come back, to have a chat with their manager, perhaps to a training session, or to work on a project. So the thing to note about kit days and with split days are that they are voluntary, they're not obligatory, and they're not compulsory. So your employee cannot insist on having a split day. Equally, you cannot insist that your employee come in to work for a split day. And if you do, or you penalise your employee for not attending a split day, then that amounts to a detriment. Terms and conditions of employment during shared parental leave. Well, these are the same as statutory maternity leave and statutory adoption leave. So in essence, an employee who is taking shared parental leave is entitled to the benefit of all terms and conditions except pay. Now, pension rights continue to apply, but only during a period of paid leave. Employees will be protected from detriment dismissal for taking leave in the same way as females are protected for taking statutory maternity leave and pay. And just, this can take us into another whole area of technical complexity, but benefits under salary sacrifice scheme have to be treated the same as other non-cash benefits. So you cannot refuse to provide them simply because the employee is not being paid, and that can actually result in employers losing out from time to time. But there it is, and this is a particularly complex area, so I'm not going to say any more about that. So what does an employee, what is their right to return to? Do they have the right to return to the same job? Well, again, this is exactly the same as the current statutory maternity leave provisions, where a woman has the right to return to the same job so long as the total leave taken is not more than 26 weeks. So in the case of shared parental leave, if the total leave taken, whether continuous or discontinuous, is more than 26 weeks, then it might not be possible, it might not be reasonably practicable to permit the employee to return to the same job, but in that case, their right is to return to another suitable and appropriate job on no less favourable terms and conditions of employment. Now, this does not apply where it's not practicable to continue to employ the individual due to redundancy, which we're going to come on to shortly. So that's really a summary of the rights and protections afforded to employees who are on shared parental leave. So, so the ACAS guidance, I would recommend that employers read this guidance, and actually I would recommend that you notify your employees of the guidance, because it's very helpful, it's very user-friendly, and it's not a statutory code of practice. That's something to mention. So it's not legally binding, it's simply guidance. But as we know, employment tribunals and employment judges do like ACAS and ACAS guidance. So whilst it's not statutory or binding on an employer, it's good practice to ensure that your policies and procedures do keep in line with the guidance. So the ACAS guidance, it gives a nice overview of the SPL entitlements. It introduces the main aspects of shared parental leave and shared parental pay. And I think this is where it's helpful for employees as well as employers, because if you think about it, employees are going to be grappling with this, whether they're entitled, whether their partner's entitled, how much time can they take off, in what periods, what patterns, etc. So it's a nice step-by-step guide for employees as it is for employers. The other thing it does, it provides links to further advice and support. And at this stage, I think I've already mentioned the BIS technical guidance for employers, which is my choice of bedtime reading at the moment. But I have to say, I can't rave enough about that guidance. It's really well written, it's really detailed, and it does answer the most technically complex questions. Now, the other thing I would say, if you go onto the BIS website, there are a number of other guidances as well, which are less technical. And the other thing that I discovered, but I can't rediscover it, so I went again onto the BIS website, but there was like a ready reckoner at one point. And I'm sure if I were to navigate, if I went onto it again, I could probably find it. But what you could do, and certainly as an employee, what you can do is the same as working out what your statutory redundancy entitlement is with the ready reckoner there. You can work out what your entitlement to shared parental leave and shared parental pay would be. So it asks questions about you, what your earnings are, what your continuity of employment is, and then it asks questions about your partner. And I would certainly be recommending using that link. If you're creating policies and procedures, put or make reference to that link, because it's a very useful starting point for the employee. Just returning to the issue of redundancy. Now, just a reminder of the position. If you have a woman who is on maternity leave and whose job is potentially redundant, she might be one of a pool of potentially redundant employees. If a suitable alternative vacancy arises, you, the employer, as a matter of law, must offer that suitable alternative position to the female on maternity leave before you offer it to anybody else. Now, this has undone many an employer who have not been aware of this provision. It's a Regulation 10 provision, that's what it's known as. And it's, on the face of it, can appear unfair because the woman, might not have been in employment for a year, and yet they're entitled to this suitable alternative position over other employees who have been with the business or the company or the employer for a considerable period of time. The female might not be the best candidate for the role. It doesn't matter, because by virtue of being on maternity leave, her rights trump everybody else's, including, interestingly, potentially disabled employees. But this is a black letter of the law right. And if you don't offer her that suitable alternative vacancy and she's made redundant, then that amounts to automatic unfair dismissal. Now, the same right applies to somebody who is on statutory adoption leave, and the same right will apply to those parents taking shared parental leave. So that is something to be mindful of. If you have an employee who's on shared parental leave, whose role becomes potentially redundant, and there is a suitable alternative vacancy out there, it has to be offered to the person on shared parental leave as a matter of law before you offer it to anybody else. Okay, so shared parental pay. You see, when the government goes on about social re-engineering and smashing stereotypes and making fathers responsible for the care of their children, etc., I think that's laudable, but the reality is when you're paying fathers a flat rate of £138.18 per week, it's not really going to happen very often. And we've seen that with statutory additional paternity leave, which is already out there, and we know that the take-up of statutory additional paternity leave is very low indeed. And this is why I'm a bit of a cynic. I don't think that for all the government goes on about this is a game changer and in gender equality, etc., I don't think it will be, because until employers are prepared to pay enhanced shared parental leave to both employees, I don't think there's much of an incentive for a father to actually take time off to care for their child in the first year. Just to remind you of what the position is, the flat rate is throughout, so that up to 37 weeks can be paid at the flat rate of £138.18 or 90%, whichever is lower. And during the shared parental leave, the employee is entitled to the benefit of all their existing terms and conditions except pay. As we discovered earlier, salary can stop, but non-cash benefits do continue, and employer pension contributions continue whilst the employee is being paid, whether they're being paid statutory or occupational pay. So, if you decide to enhance the benefits to parents who are taking shared parental leave, whether that be pay or bonuses, return to work bonuses, you have to offer those enhancements to both females and males who are taking shared parental leave. I don't think that's particularly controversial. The bigger and more controversial question is, what if you as an employer, to make yourself an employer of choice, offer enhanced terms to women who are on maternity leave, and you frequently have perhaps up to 26 weeks full pay, the balance at statutory flat rate, or it may be that you offer a return to work bonus for those who return after and remain in employment for 6 months. They get a bonus. There are variations, a number of variations on a theme, and they're quite common in the case of maternity leave policies. So what if you offer these benefits to women on maternity leave, but you are not intending to offer the same to employees who take up shared parental leave? Could that potentially be discriminatory? Well, the government is very clear that no, it will not be, and anything you read from the government is saying you cannot compare the position of a man or a partner, female partner, with a woman on maternity leave. They're in a special category and are afforded special protection. But it's interesting because we've recently had a first instance employment tribunal decision, and that was the case of Schutter and Ford Motor Company Limited. And in this case, Mr. Schutter was one of very few men who'd taken statutory additional paternity leave. So his wife went back to work, and after 20 weeks, he decided to take the statutory paternity leave. Now, he was only entitled to £138.18 or whatever it is, the flat rate of pay for that period of paternity leave, up to 26 weeks. Now, Ford's practice was to pay, and still is to pay, women on maternity leave 52 weeks full pay. So that's very generous. I'm not sure I know many employers who offer that level of enhancement. And what Mr. Schutter did, because he was employed by Ford, he said, I think this is discriminatory. Here I am, I'm taking time off to care for my baby after 20 weeks from after birth, but I'm only entitled to £138 per week. My colleague, who happens to be a woman, after 20 weeks, she continues to be entitled to full pay right up to the end, up to the 52 weeks. I think that's discriminatory. And he brought a claim for both direct and indirect discrimination. Now, when he brought his claim for direct discrimination, the tribunal looked at it and he said, well, no. He was trying to compare his position with the female on maternity leave. And the tribunal said, you've got the wrong comparator. You have to compare your position with a female partner of the mother, because statutory additional paternity leave also applies to females in a same-sex marriage or same-sex relationship. So you have to compare your position not with a mother who's on maternity leave, but with a female partner also seeking to take additional paternity leave. And in those circumstances, Ford will pay them at the same flat rate of £138 per week. So no discrimination, no direct discrimination. So then he said, well, I believe that the practice of paying full pay to women after 20 weeks, but flat rate to men after 20 weeks is indirectly discriminatory because it's a provision criteria and a practice which has an adverse and disproportionate effect on men. I've read this case and I still don't get why they conceded on this point, because I don't think it was the right test. Anyway, Ford did concede and said, okay, we're prepared to accept that this is potentially indirectly discriminatory. However, we can justify, because of course you can justify indirect discrimination, you cannot ever justify direct discrimination. But we can justify what we do, we can justify paying women more than men, because we are a male-dominated industry. And we believe that providing very generous maternity benefits to women is a proportionate means of achieving a legitimate aim, and our legitimate aim is to attract more women into our company. And they had loads of statistics, they had, really good evidence to support that argument. And the tribunal accepted that, yes, potentially, that practice was capable of being indirectly discriminatory, but Ford, with all the evidence it had adduced, was able to defend it as a proportionate means of achieving a legitimate aim. So it's only a decision at first instance, and as I say, I don't really understand why Ford conceded on the indirect discrimination, and I can't get the full transcript of the case to read it. But the point to note is this. In the past, women who've been on maternity leave have been given this special treatment, and it's been accepted that men cannot compare their position with a woman on maternity leave. But if you look at ECJ case law, and there are a few cases, what the courts seem to be doing is recognising that a woman on maternity leave is entitled to special or differential treatment in connection with childbirth and the need to bond with baby. So this is a biological condition that entitles them to be treated separately or specially or in a different way. But that special treatment doesn't continue simply to care for the child. So, yes, treat a woman differently. She's entitled to special treatment for the bonding purposes, for reasons connected to childbirth. But in connection with childcare, no. And we've had some case law, particularly there was a case, a Spanish case, where a male father was not entitled to take time off during his day to bottle feed his baby who was in the creche, whereas a woman was. And he said that's not fair, that's discriminatory. And the ECJ held, yes, it was discriminatory because this is childcare now. This is not special bonding or connected with childbirth per se, but the difficulty is knowing when it moves from the biological condition, which does attract special treatment and more favourable treatment, if you like, into childcare. It's not clear at this stage. And you could say, well, given that parents are able to split, share maternity leave by way of shared parental leave after 2 weeks. You could say, well, is it not after 2 weeks? That special bonding period lasts for the 2 weeks, but given that the government is allowing the mother to share the balance of the maternity leave with a partner, is it to that point? I think it's not at that point. I think it's a longer period than that, but this is where, it's not very clear. And I would say, I think this is going to be an area that will be tested. I think there will be male employees who are going to try and argue indirect discrimination. You've got the Ford case. Ford were able to justify it because of they were in a very male-dominated environment and they wanted to encourage women in the workforce. So I think it's a question of watch this space. Sorry, I'm just trying to move the slides on. Sorry. So if you do offer occupational enhanced pay, here are the options in terms of maternity leave. So if you only offer statutory pay for maternity, women on maternity leave, then you can use the same approach for shared parental leave, and there is no danger there. If you have the continue to enhance pay for maternity leavers, but pay shared parental leave at the statutory rate, well, as we've seen, there may well be challenge. So you might want to think about, if you were challenged, what would your objective justification be? How would you justify paying a different rate to women than you would to those on shared parental leave? Obviously, you could level up and introduce occupational shared parental pay to equal the enhanced maternity pay. And I know certainly the civil service has agreed to do this. And so shared parental pay will be available to both men and women at full rate of pay for I think up to 26 weeks. And obviously there are certain accounting firms that if you actually Google this, you will find that, you know, those who are levelling up are very keen to tell everybody about it because, of course, they want to promote themselves as an equal opportunities employer. You know, they want to perhaps promote the government's objective of this new approach to childcare. And that means, the reality is, as we discussed earlier, well, as I opined earlier, until men are paid a reasonable amount of pay, the chances of them taking up shared parental leave are slim. Now, the other quite controversial suggestion in that box is levelling down, so to remove any existing entitlement to enhanced maternity pay, so that you're then paying both at the statutory rate. Obviously, that's something that you can consider. You need to be careful that maternity leave policies are not contractual, because if they are, that poses a whole raft of other considerations which are quite complicated in the legal sense. But obviously it also has an impact on morale, and really it depends on how you want to promote yourselves as an employer, and what sort of employees you want to attract. So finally, I seem to have whizzed through this, the to-do list. So if you don't already have a shared parental leave policy, then you should be drafting one. As I said, make cross-reference to the Biz Employers Technical Guide and the ACAS guidance, and also to that Ready Reckoner if you can find it. Obviously, you'll then need to update all your existing family policies. So, for example, you might have a lovely, splendid additional statutory paternity leave policy, which effectively, after the 5th of April, is redundant, albeit that it will still apply to those whose babies have been born before the 5th, or the due date before the 5th of April. Then you need to establish a process for how you deal with eligibility and notification requirements. And as I mentioned earlier, the policy itself is just really, or should be, the starting point. What's really key, I think, when you're looking at creating policies, are the forms that the employees fill out, because that's where the clarity comes about, and you need specific forms for each stage of the process. Obviously, if you already do offer enhanced maternity leave benefits, then you need to determine, are you going to enhance benefits for shared parental leave? If not, what would your objective justification be if you were ever challenged? And then obviously there's the whole communication to your workforce and training line managers on these provisions, because they might have quite a shock to realise that, you know, all of a sudden fathers are entitled to extensive periods of leave, and also that their employees can actually request discontinuous periods of leave, which they might find problematic. So that's it from me. I'm not sure if there are any questions. Right, so this is an interesting question. So what reasonable measures do we need to take to ensure the partner is economically active? Do we have to contact the partner? Well, this is where the government suggests not. You can, when you are seeking the declaration from the mother, you could, if you wanted to seek to get her consent, that you can approach her partner with this question. There are Data Protection Act implications, but what the government says is it's not really necessary to do that because the economic active test is very low, it's a low threshold, and they seem to be suggesting that if the parents defraud the system, because obviously they're both entitled to up to 39 weeks statutory pay for the shared parental leave period. So that's the maximum entitlement. And the government reckons that through HMRC, if the parents are seeking more than that 39 weeks statutory, they will find them out. So the strong thrust of the guidance issued by the government is really that it's not necessary for the employer to do it, that you almost have to take what your employer is telling you at face value. And what I would be inclined to do is have in your policy that any fraud or any false declarations submitted by employees will be dealt with as a disciplinary offence. Okay, well that's the one and only question. So I hope that today's session has given you some clarity around the regulations. As I said, if you do have any more complicated technical questions, then please contact your usual contact within gunnercooke, or I'm happy for you to email me direct. But in the meantime, happy reading.